Day 2 of public hearings at the International Court of Justice have come to a close. The hearings are meant to establish an ICJ advisory opinion on obligations of Israel towards its occupied territories and its breaches of international law in blocking aid from entering Gaza. Michael Lynk, a Professor Emeritus of Law at Western University and a former UN Special Rapporteur for Human Rights in the occupied Palestinian territory. Pleasure to have you on, sir. You joining us from London, Canada, I note. Let's just start then with the reality, which is that Israel's killed tens of thousands of civilians, women and children, a large proportion of them. It's also now clearly starving people in Gaza by refusing them access to food. What laws is Israel breaking by doing all this?
War, in effect. The two main laws that are going to be governing this are the 1949 Geneva Conventions and the subsequent developments of those Geneva Conventions, which is the beating heart of international humanitarian law. A secondary of law, which is not before this court, but before the International Criminal Court, is the Rome Statute of 1998. Both the 1949 Geneva Convention and the 1998 Rome Statute strictly and absolutely forbid the use of starvation against the civilian population during times of war and conflict and occupation. In many ways, what the court is hearing this week on this relatively narrow question of what are Israel's obligations towards the international community and towards the United Nations is a preview of what the court will be hearing in a year or two on the South African application under the Genocide Convention against Israel for the way it's conducted its war over the last 18 months. We've heard that in the arguments yesterday and today, severely criticizing Israel for the use of starvation, for cutting off water, cutting off fuel, and cutting off medical supplies going into Gaza.
The problem as I see it, and you can correct me on this, is that this is just an advisory hearing. So what we're going to get coming out of this isn't going to have any teeth. Israel's just going to dismiss it. And even when we look back at what happened at the ICJ last year, looking at the South African claim that Israel was carrying out genocide, really nothing came of it. Again, nothing tangible that could be used to hold Israel to account. I hear so many people tell me international law is not fit for purpose anymore. What's your opinion?
International law is doing what it should be doing. It's directing attention to those who are breaching the fundamental rules of human rights law and humanitarian law with respect to this. The problem is that in our current system, international law doesn't have armies. It doesn't have police in order to be able to enforce this. These courts can pronounce and say this is right, this is wrong, this is illegal, as it has done in the advisory opinion released last July, saying that the Israeli occupation is illegal. But where the true locus of power is with political will. And there we have to turn to the United Nations, and specifically the United Nations Security Council. And we know over the last 18 months, as this war has dragged on, the United States has a veto power. And whether it's the Biden administration or it's the Trump administration, they've shown their willingness to use their veto power in order to blunt any application of international law. So then you ask, well, what is to be done? Well, really, we have to turn to other countries, and particularly in Europe and in the global South, to want to start imposing greater and greater costs on Israel, economic, diplomatic, trade, weapons trade in particular, to ensure that they're brought back within the bounds of international law. It is, I should point out, a powerful message to be able to say something is illegal, something is against the fundamental principles of international law. That's going to have to then be raised by civil society organizations and human rights advocates to be able to bring that message home.
You talked about the fact that the court actually doesn't have a method of enforcing the decisions that it concludes. So it's an ideal. It's a ideology that it comes up with, that this is how people should behave, but it has no mechanism of enforcing that. Have we lived in a world for too long where the United States has been the enforcement mechanism, and the problem comes when the United States isn't in agreement with the result, or is a strong ally of the party that is going to reap the consequences of the judgment?
Look, you put your finger on the problem here. Let's keep in mind the issue of Israel and Palestine is the oldest item on the UN agenda. It was put on the UN agenda in April 1947, 78 years ago, and it still remains unresolved and perhaps more unresolvable than ever today in 2025. In his very eloquent memoirs, former UN Secretary General Kofi Annan said that when it comes to the Middle East, the Security Council has shown an unusual degree of paralysis in trying to address this long-standing issue. And he pointed his finger at the willingness of the United States to veto, he said, even reasonable resolutions critical of Israel. We had a resolution from the Security Council in 1980, which said that it's long overdue for the then 13-year-old Israeli occupation to end. And yet here we are 45 years later, and the United Nations in general and the Security Council in particular have been unable to move. And it's the focus of that, as you are absolutely right, is on the United States. They have wielded more vetoes in favor of Israel than any other situation in the modern world where they've issued a veto. And in fact, they've issued more vetoes than the rest of the four Security Council members who have permanent vetoes together when it comes to the entire world since 1967.
Michael, greatly appreciative of you taking the time to come and speak to us on this important matter. Michael Lynk is my guest. He's a former UN Special Rapporteur for Human Rights in the occupied Palestinian territory. Thank you.
Thank you.